Welcome to Advocates for Justice Paralegal School. I'm Coach Neighbors. Today we're going to update you on the success of the new 42 USC 1983 Foreclosure Offensive Civil Rights Lawsuit Package. We've got a couple of wonderful reviews we're going to be sharing with you guys. We're also going to cover some related stuff that you guys using the new lawsuit package must be aware of. Today I'm going to be asking a few questions and let you guys ponder on those questions and see what you think. So let's just start out with the first question. If there was any way you could challenge your mortgage payment before you go into default, who would be interested in doing that? Who would like to save that mortgage payment in their bank account? If there was a way to do that, would you be interested? Well, we'll talk about that a little bit more, a little bit later on in the video. Now, I'm not an attorney, so my documents contain the elements that the Federal Rules of Civil Procedure mandate must be present. I also make sure that my documents contain the elements noted in the state filing requirement statute, which are very liberal. So you'll need to keep that in mind when you're using my stuff and they're trying to give you a bunch of crap about filing my stuff. You need to keep in mind the other BS court rules that they want you to follow are the local rules. And the local rules are not in harmony with the Constitution. In my opinion, the local rules were crafted together for the attorneys to use to speed things up through court, to hurry up. So anybody with the whole brain or half a brain knows that anytime you're in court and they're speeding up the process, you're getting the shaft. So yeah, you're getting screwed. That's pretty much a given. You're not obligated to follow the local rule. I don't follow the local rule. And when they try to give you a hard time about this, ask them, wait a minute, my legal team did not see what you're saying in the Federal Rules of Civil Procedure. The Federal Rules of Civil Procedure are the rules that everyone is supposed to be following. And the extra stuff they try to make you do is not in the Federal Rules of Civil Procedure. I'm not subject to following anything that's not in harmony with the Constitution. And that's exactly what I would tell them right out the gate. Now, one of the things I want to touch on, when you guys get in my program and invest in a lawsuit package, you're going to need to forget everything that you have learned already. All of that stuff that you learned that the attorneys have been teaching us for 150 years, all that stuff you need to forget. That's all conventional. We have a non-conventional program. That's what we do. In my program, you will learn how to control the court by suing the players, pretty much. You're going to be suing the people who actually signed to start the problem that you're dealing with. And in most cases, it's not the lender. That's the biggest mistake that most people make in thinking the lender is the one coming after him when it's not the lender. It's the attorney who signed acting as a third-party debt collector. And they're lying because the lender is not involved when your house goes into foreclosure. Now, what we do with the 42 USC 1983 Civil Rights Lawsuit Package is perfect for you guys. Well, it's perfect for everybody, but it's even double perfect for people in non-judicial foreclosures where they're trying to take your property without providing due process or giving you an opportunity to get into court and defend yourself. Perfect for that. My 42 USC 1983 Civil Rights Lawsuit Package is perfect because it addresses the illegal court procedures. Everybody wants to argue case law and all that crap. Well, when you get done, it's a procedure that beat you in the face. You will sue the state, the judge, and the attorney for violating you with the court's illegal process and procedures. The court process and procedures rob you of your due process right out of the gate. My program is structured to help you negotiate the delivery of your original property deed. I don't talk about that much because people think I'm crazy. I tell them there's a problem with their property deed. They look at me right in the eye and say, oh no, it's just fine. It's in their office. Well, I think you guys are figuring some things out now. I just don't talk much about it because people think I'm crazy because they believe the lies that bar members have indoctrinated us to believe as true. So we're going to talk about what's really going on here. What's really going on is real estate deed fraud. And it's real estate deed fraud because the state law mandates that the deed to your property be delivered to the homeowner after fraud deal. I mean, after the deal, the mortgage fraud deal. Did you guys get your deed delivered? Okay, I won't wait too long. Hell no. No, the bar members did what they call their constructive delivery, and they registered your deed in their office. And then they delivered your ass a worthless copy. That's pretty much how that went down. Would you believe me if I told you that the first lien that was placed against your property was the mortgage lien, and the mortgage lien was illegal? Think about it for a second. If there were several people who owned property, all of the owners would have to be present to sign the mortgage lien against the property, right? In fact, the lender accepted your signature on the mortgage lien, verifies that you own the property before you sign the lien. So the illegal mortgage was filed after the property was registered in their office. Now see, this is where my expertise is. I love picking at their process. Now, I don't think people know there is no law that mandates you must allow them to register your property in their office. There's no law. There is no law that forces you to let them register your property in their office. Oh yeah, I know what they tell you. Oh, the chain of title is going to be broken and all of this stuff. No, that's such BS. At the end of the day, their chain of title is already broke because they don't have the documents in there in the first place to be doing anything that they're doing. So that's at the end of the day. Now, at the beginning of the day, whether or not the chain of custody or the chain of title is right is only is important if you're trying to sell your property. Other than that, and this is what people don't realize, there are people who have their property paid off. They have the lien released, the property, they have all that stuff, but their property is still in foreclosure. So how the hell could that happen? Well, these attorneys go down to the office where they have your property registered at and get your property information, and they fill out a fake assignment and come after you because they know that they have a 99% chance of getting away with it because nobody can afford an attorney. And if you do hire an attorney, have you a foreclosure, that attorney automatically gets a cut of what they steal from you to throw you under the bus in the end, in addition to what you give them out of your bank account for the fake help. Now, somebody tell me if I'm wrong. Because I've been watching this go down for a minute. There is no law that forces you to leave your property in their office. My question is this: if your property deed was not registered in their office, would the alleged lender be able to verify that there was a mortgage lien against your property? Think about it. I don't know. I'm just asking these questions. And when I get done asking these questions, please don't call me and ask me how many people won using this, okay? Because I don't even want to hear any of that. This is something new that we're doing, and the only people that are using it are the people that have the courage to step up to the plate and do whatever it takes. Dream big. It's pretty clear that I'm a pretty big dreamer. And a lot of people told me I was crazy a couple of years ago when I told them that I was going to be helping people stop foreclosure so they can get to stay in their house. That's my goal. Get to stay in your house. That's my guarantee. And we doing it. Let's get back to the question. Can you stop making mortgage payments if your deed was stored in your family Bible in the fireproof safe? Think about that. Can the lender prove that they made you a loan if they do not have access to your property deed? Would they be able to send you your property tax bill if they didn't have your okay, I think you guys are catching on here. Could this strategy be the best way to challenge your mortgage foreclosure before you are in default, before you're late on payments? I don't know. I'm just asking. This is going to be for people to watch the instructional video and figure it out. So I'm just asking you guys. I wonder if you can use this for that. What if you could challenge your mortgage payments while you're still making payments with this new civil rights lawsuit package? Can you sue the state, the lender, and the attorney for the illegal mortgage lien? I'm wondering, do you have to wait until you're in default to sue them for their fraud? I'm just asking. I want to know what you think. If you had control of your property deed, can the alleged lender sue you in court? They'd have to be able to prove that there was a lien against your, I don't know. Would you be able to formally request your deed be delivered to you as mandated by state law? Well, if you use my lawsuit package to back them into the corner, that's exactly what I would be doing. I would be backing them into the corner and then offering them a settlement agreement. And in that settlement agreement, the number one thing would be to deliver your property deed to you as mandated by the state law. The number two thing in your right would be to remove your property information from their website, from their database, and all of that. And probably number three would be to contact the credit reporting agencies and correct the lies that were sent over to them. And then now we're to the money part. So you guys will figure out the money part on your own. I had a person call me today and ask me, well, how much can I ask for I like this. Of course, this guy hadn't invested in my program. He was just asking me a question. And I tell him it depends. If you want to follow their local rules and you can only ask 1.5 times or whatever, or you want to follow your own rule and do, I put 5.5 million on everything, like Frank's hot wing sauce. Yeah, you guys know the commercial. I'm not saying any bad words. This lawsuit package is limited only by your imagination. And I'm going to show you guys some of my reviews that came in on this package. This first review here came from an attorney who left a review on my website about our marriage dissolution document. It's a positive review. I'm not used to getting these kind of I'm not used to getting these kind of reviews from I'm not used to getting these kind of reviews from an attorney law firm. Now, this is the latest review that came in on the 42 USC 1983 Civil Rights Foreclosure Offensive Package. I changed one word because, well, I changed it to just the letter F. So I think you guys can figure out. You can figure that out. This review came from Stinger, who is a subscriber on my YouTube channel. And he left quite a bit on the channel. He was very impressed with this package. So here's another review he left. Well, actually, that's the second part of it. And here's another review that came from Venus. Now, Venus was facing a property tax eviction process, and she used the 42 USC at the last minute. And well, you can see here, they dismissed her case. And she says here she was in tears because she gets to stay in her house. That's what I'm talking about. Yeah, that made my day. And then this is another nice review. We're just going to move it down on one page that came in from Win Victory. And she was running behind also. And she got control of her situation. So you guys can see my reviews here are pretty cool. Now, this lady was really special. She was injured in a bus accident, and her attorney is throwing her under the bus and stalling her out of time to collect on her claim. So she bought the 42 USC civil rights package, and she sued the state, the judge, the court, and she included the other people's attorney and her attorney that she hired to help her. She sued him too. And they called her the next day wanting to do mediation, and she ain't having it. So you guys can see all of these reviews came from my Google review page. Some of them came from emails that came straight to me. So we have a lot of happy people. That's all I got to say on that. I'm going to show you the page on the website that had the 42 USC 1983 Civil Rights Lawsuit packet right there on it. Okay, here we go. This is what the page looks like on my website for the 42 USC 1983 foreclosure defense civil rights lawsuit package. So we got a little information there about it. And then this is a link to my Sam's cart where you can actually go and take a look at a page that I put together. And I use this because I'm able to put these videos in this page without slowing down the loading speed. So you guys can go here and learn more information about this. I want everyone to watch the videos and even take a look at the package or consider purchasing it. I want you to take a look at what you're getting and watch the videos so you understand what you need to do to make this work out for you. So here's the description of it. And then we talk a little bit about exactly what you get. Okay, so we're back in action. If you guys are facing this problem, you need to head over to my website at winincourtnow.com and take a look at the options that you have. Make your investment, and let's get started. Thank you guys for the privilege of sharing your time, and I'll see you in the next video.